Ladies and gentlemen, we're going to try to start more or less on time, which is 15 minutes late, and try and get through the program more or less on time this afternoon. The next item on the program is our only dual presentation. I date myself if I called it a Bob and Ray show. I guess these days it's a Bob and Doug show. Our two speakers are, on my right, Donald Brown. Don is going to present the legal side of the issues on this section of the program. Now, there are a number of things here on Don's curriculum vitae, and I keep looking for something unusual about people. Now, Don was educated at Osgoode Hall Law School. That certainly is not unusual. He practices law at Blake Castles, and that sure as hell is not unusual. And he has a master's from Harvard. That's not all that unusual. But let me tell you, for one day in 1966, he was an assistant lecturer at the Faculty of Law at the University of Singapore. I bet there's nobody in this room who can beat that. On my left is Peter H.R. Peter is one of these either kind or foolish people who, being a non-lawyer, is willing to come and speak to a group of hundreds of lawyers. Peter is a professor in the Faculty of Administrative Studies at York University, which I think is up near Maple somewhere. And in addition, is president of a company called, of all things, Peter H.R. Alley Management Services Limited. Peter's areas of interest are management strategy, strategic planning, and financial administration. And they're going to talk to you today about the strategies involved in corporate litigation, which I'm sure is a subject dear to the hearts of all of us. So I will turn these, not the podium, the lower level, over to Donald and Peter. Thank you.
Thank you, Jack. Your reference to the McKenzie brothers brings to mind the comment. Last night,
what'd you say, Don?
yeah. Last night we did a trial run of this, and when it was all over, one of my partners told me that we were going to be the Law Society's answer to the McKenzie brothers. And I'm sure they're not too far off the point. As Jack said, our topic today is really commercial lawsuits, or commercial disputes generally. And we together have both experienced a substantial increase in the complexity of commercial disputes and commercial litigation, and a corresponding significant increase in the costs of their resolution. Both of us have had a recent experience, mine in connection with a lawsuit, an almost tried lawsuit, where the settlement value of the case was in the vicinity of $500,000, and adding together management time, legal fees, accounting fees, and other experts' fees, they totaled as well $500,000. Peter's experience was with a smaller case where, again, settlement value after discoveries was approximately equal to the out-of-pocket costs of the experts and lawyers involved in processing it. And from what we hear, as well as what we experience, both clients and lawyers are seeking a better way and being more interested in finding a better way for coping with commercial disputes. You know, the common approach, and the approach that we're all familiar with, is one where a dispute gets categorized as one requiring some legal help, gets wrapped up in the files, and maybe a covering memorandum is sent to a litigator, and managing that dispute is largely equated with letting the litigator take the dispute through the traditional channels. Company management's role is often just left to giving instructions, which are in the form of hearing a recommendation and responding, yes, go ahead. Settlement discussions and negotiations occur, if at all, and they usually do, not early in the process, but but late in the process. Commonly, the problem arrives on a lawyer's desk. He looks and gathers a few facts and responds in a traditional way of issuing a writ or filing an appearance in a statement of defense. Before much happens, time for discoveries are scheduled, and the response is often, let's get through discoveries and see where we stand. And in the normal mode, litigation mode, serious settlement discussion does not occur until very late in the game, and often in the eve of trial. Normally, as part of this mode, active management of the dispute does not occur. The style of handling that problem is often and commonly more reactive, and any attempt to manage the overall problem can sometimes fall between two stools. Where Peter and I are coming from is basically a belief that there is a growing need and a growing desire, certainly in companies, to better handle their commercial disputes, more efficiently and more effectively handle them. And we see this as possibly being accomplished by adapting to the management of a traditional legal dispute a more active and overall business management of the process of dispute resolution. And as part of that, adapting some of the tools of analysis that are commonly used in a business concept for dealing with issues of uncertainty. And thirdly, considering a different approach to the negotiation of these disputes than one typically found in the mode of in a litigation mode, if I can use that phrase. Now, Peter, you want to elaborate a bit on what we mean by managing the legal dispute process.
Yes. The first point that we really want to bring to bear on the consideration of a dispute is that that one can be active in it rather than just let it happen to you. What does management mean, management of the process? Well, it's the management of a project. Management of projects is something that management has a lot of experience in marketing, in R&D, in building buildings. It's something we think can be transferred to this kind of problem too. It starts with a need for the problem identification and some analysis. With analysis, it's necessary to look at the returns, the costs, and the risks. Those are concepts management is already well familiar with and usually does quite well. Associated with this problem identification and analysis is a recognition of what the interdependencies are with the other side. What the claimant might want to do is limited by what the defendant will allow, and vice versa. So that interdependency is something that needs to be analyzed. In addition, there are uncertainties. Uncertainties about amounts of damages, uncertainties about points of law. Those two can be analyzed. There are frameworks for doing it. Second thing, after the problem identification and analysis, there is planning. Planning means identification of the tasks that have been flowed out of the analysis, a sequencing of the tasks, or scheduling, and an allocation of resources to the tasks that seem to be important. The third step in management is that there be a directing of the execution of the tasks, and that is the integration of the activities of a team of people who will be involved in the dispute. There will be corporation lawyers in-house and outside. There'll be litigation lawyers. There'll be experts. There'll be company personnel. All of these are part of the resources which have to be managed and integrated and kept working together as a team. The fourth step is that there be some control over the process. Control is established by monitoring the progress and the costs against the schedule that was set up in the first place. And finally, in any management task or management operation that's done well, there will be periodic reevaluations of where you stand. Do you still want to go ahead in the route that you've been going? Do your ideas of what your interests and what the values are to you, have they changed? That reevaluation has to be a part of the process periodically. Now, the next step, we said that there were three things we wanted to talk about: the management of the process, and some analytical tools, and the negotiation. We turn to the question of the analytical tools, and I'd like to suggest to you what we're looking at and why. If there is a dispute, there will be somewhere in the dispute what we call a zone of agreement. There can be an expectation of what the probable outcomes are of the case, and that we've marked on this chart as the trial outcome. These aren't in your, this one isn't in your handout, but we'll come back to it later. An additional element in the analysis is the legal costs, and another one that is important and can be even more important than the legal cost is the value of management's time. And finally, the third element is the risk premium. Now, if both sides face these costs and a willingness to pay a risk premium, the particular amounts for each individual differ with every case, and they are different on both sides of the case. It's not a symmetrical distribution. What we think is possible is to analyze a case in a way that will shed some light on what that zone of agreement is, how big it is, and some of the characteristics that underlie it. And if you have done that, then you are in a position to move on to negotiation. So what I'd like to do is run through some of the kind of analytical tools that we think will be helpful in identifying what the elements are in that zone of agreement. Don, to do this, we had identified a little case. Would you give us the...
It's included in the handout, and it has to be partly explained. We found that for illustrative purposes, we had to get such a simple case, and for a 45-minute talk, that many of the things that we will be demonstrating, most of you in practice will see intuitively. Nevertheless, it is useful, we think, as a means of illustrating the use of the analytical tools that Peter will deal with. The case is a wrongful dismissal case involving a company that we've termed Acme. They terminated their 61-year-old chief executive officer. He was earning $96,000 a year, been with the company 36 years, last 6 as president, and 42 months to go to retirement. Pension at 65 is $10,000 less than it would have been had he remained through to retirement, and his lawyer, his name being Jones, demands reinstatement for the 42 months, make his client whole in the familiar legal terminology. So with those facts, now Peter will take a quick look at some of the traditional business management analyses as applied.
Okay. The first task that one has to do in a decision analysis is to identify the alternatives. This too, you have a slide that's a little more elaborate than this, but if you just look at this for a minute, you can see that we've put together 3 possible kinds of decisions that might be made. Decisions about acceptance of the offer, about negotiating, and about going to trial. There are 2 simple forms of probabilities here. Questions of the probability about when he will get, Jones will get employment, and they're also about when or what the outcomes of the trial would be. And we've simplified here and said there are 3 possible outcomes of a trial, and one is that 12 months, which in effect is Jones loses. The other is that 22 months, which seems to be, I think that, isn't that, you tell me, Don, that's the maximum that's so far been recorded in court. And we said, in this case, he might get 42 months. And there might be some reasons for arguing that in this particular case. We assigned some probabilities on those. One might argue about those. Those may be important. There's also the questions about when he'll get employment. Now, one might put different probabilities and different sort of outcomes, but this is illustrative. One can make this much more complicated. We've tried to simplify it a little bit. So the identification of the probabilities is important. Identification of the sequence of steps is important. The next thing that's important is to put some present values on that. And in Exhibit 1 in your outline, we have identified the present values for a single one of these outcomes, and that is that it takes 12 months for him to be reemployed, that he goes to trial, and he wins 42 months. And the elements of what the value of that is show up in a calculation similar to this. One calculates the amounts, one looks at the times at which they will be received, and then one does or calculates a discount rate. So what we look at is the amount of what was the damage that would be expected in that case, what are the legal costs, what is the management time, what is the timing of these payments out, and what is the cost of money to Acme. Having established that, one can put a figure for that single set of circumstances of $173,000. One can take that, do that for each of the alternatives, and this you have in your handout as Exhibit 2, and we have made that calculation with a bunch of other particular assumptions that we thought were reasonable in the case, and we've come up with numerical values for each of those possible outcomes. One can go further on that, and by working through this decision analysis, one can come to what's the preferred route for each, for Acme. Jones could do the same for himself. And you can also figure out what is the expected value of a trial outcome under the various circumstances. Now, the next thing that one has, that expected value of the trial outcomes becomes that central number in the zone of agreement chart that we talked about earlier. Now, the next thing that one has to do is look at the risk premium. Let me explain just in a minute what we mean by risk premium. It's the amount of money that a person would pay to someone else, or rather, let me put it this way, a person would accept, because we're looking at conventional terms, the amount of money that you would accept from someone else to buy your right to a bet. What you would pay for, well, lottery, what you'd pay for insurance. You're making a bet with the insurance company. There's a probability that your house will be destroyed or your automobile you'll run into somebody. That's a bet. And you pay an insurance company to take over your risk. And you pay them something more than the mathematical probability of that risk. The difference, that something more, is your risk premium. I'm sure you're all familiar in cases where someone says, gee, you think I might get $100,000. I think I'd be happy to be rid of the case and settle for 80. And that difference is the risk premium. Now, one can approach that subjectively. It is a highly idiosyncratic figure. Each person has a different risk premium for different amounts, and it varies at different times. But you can approach the description of an individual's or a corporation's risk premium with some mathematical precision, reading what they tell you your values, and that can be described mathematically using preference theory. And that can be applied to help an analyst evaluate how the present values of those different possible outcomes of the trial would be received by, say, Acme. Now, we did that, and before I talk about how we did it and what we found, I'd like to move to the third tool of analysis that I want to talk about, and that's a sensitivity analysis. A sensitivity analysis is very simple-minded. It simply means take a chart like that decision analysis and let's change the values that we had in there for probabilities. Change the probable outcomes on the trial. And if you do that, you're going to get different expected values. And you will also get, of course, different risk preferences because the amounts are now different. The higher the risk of Acme losing, the more likely it is to pay a larger amount to get rid of the case. Very simple sort of principle. Now, sensitivity analysis allows us to look at the different possibilities and find out whether different values for the probabilities make a difference and how much of a difference. And if it's a big difference, then you may want to pay more money to be sure about what those probabilities are. And if it doesn't make much difference, you can say, that's not something we want to spend time or money investigating. And that's one of the purposes of the sensitivity analysis. Now, we did that for Acme in this particular case. And we found, for instance, that an expected value of a trial of $107,000 that they would have to pay out, Acme was willing to pay, in this case, a modest $4,000 more to be rid of the case. Now, that happens to be so because of the particular assignments we gave to his risk preferences, which might easily be different. You have to ask him what his risk preferences are. You derive it from the client. You don't tell him. And then you see whether it makes a difference or not. In fact, one of the ways you have, in all of these analytical tools, you can go around, you can test. If you think that you've got an absurd result, then you probably have, and you go back and look at your underlying assumptions on risk preferences, probabilities, and so on. So the sensitivity analysis gives you a feel for where the problems may lie in your case. Now, the next step that we will have to move into is a zone of agreement analysis. And to do that, you have to put yourself in Jones' shoes and find out what the case looks like to him. And in Exhibit 7 in your handout, we've done that. We've faced with the same sort of outcomes that are possible, the same probabilities on the case because we're dealing with the same law. And if there's a difference in view, it's a good idea to find that out early. But the differences for Jones are quite significant, and will always be significant, for some very specific reasons. There'll be differences in timing of the receipt and payment of amounts, especially if the defendant, for instance, pays into court. He's lost that money. There'll be differences in legal costs. There'll be differences in the actual amounts that, the actual amounts that may be received. And for instance, in this case, Jones receives different amounts of salary in his alternate employment, his mitigating employment, depending on when he gets the job. Looking at it from his point of view, you have to factor that difference in amount. That's not Acme's business, but when Jones analyzes it, he's going to take that into account. And different discount rates. All those create some of the elements of differences in point of view on the zone of agreement. And what you will wind up with when you have done that analysis for both sides is a much more sophisticated analysis of the zone of agreement than we talked about earlier. And here you can see with the circled line down the middle that the amounts of the expected outcome of the trial are different for each, for the reasons I mentioned, the differences in timing and the differences in discount rate. You'll notice that at the extreme end, for fun, we put the high and the low outcomes for them. And those really don't matter very much because what they're going to wind up talking about is in that zone of agreement somewhere. The orange figure shows what's actually been offered, which is on the table, and the expected value is a little lower because of timing differences, differences in discount rate, and the fact that if it goes to trial, legal costs are going to move up. The legal costs are different between the two, taking account of the probability that Jones is likely to win something, and therefore some of the costs are likely to be awarded against Acme. And then their risk premiums are different. In this case, we've assumed Jones is somewhat more conservative than Acme because the amounts are likely to loom larger in his view of the world than they are to Acme. The green X's mark the preferred course of action for each. Because each has different preferences in the outcomes, for different preferences, it means that we have some reason for a dispute. The size of the zone of agreement is the area that you have to work in for finding an agreement. The sensitivity analysis will help you identify probably what some of the interests of the two parties are, and an agreement will lie somewhere in between. Now, there's one caution here, and that is this: don't make the mistake of saying, why don't you draw a line for what the result should be? And the reason I don't do that is that that's not something that an analyst can do. That's something that can only take place in the negotiation. And Don is going to talk later along why this is so, because he's going to talk about how the pie might be made larger, that we're not just dividing a set sum. Now, Don, there's one other thing that's important to remember about this zone of agreement. That is, the zone of agreement diminishes over time. The reason it diminishes over time is that costs mount, and they're a sunk cost. So what's available for room for negotiation will diminish as those costs have been used up. Therefore, it makes sense to do this analysis early, to start managing the process, and to think about the issue of negotiation.
To talk to lawyers about negotiation strategy is maybe bringing coals to Newcastle. But implicit in Peter's and my thesis is that where you have a zone of agreement, negotiation ought to be the number one or preferred course of action for resolution of the dispute, as opposed to the alternative of a full-blown trial. And accordingly, it's important, in our view, to see quickly if there is a zone or no zone. There may be instances where there is no zone of agreement, where the tax department want to take a case and get a judgment as a matter of principle, an institutional piece of litigation. In our experience in commercial disputes, most frequently there will be a zone of agreement. In large part, it'll result from the costs of experts and lawyers that will be avoided, the risk of a result that's unfavorable, one way or the other, and the cost of management time necessary to follow the litigation route. Now, recent research into the negotiation process has suggested a model which has been dubbed principled negotiation, which to us seems to suit itself to resolution of the dispute in its early stages, in a pre-litigation mode or very early in the mode. It's quite a departure from the traditional settlement process and negotiation process that occurs later in a piece of litigation, following discoveries and maybe at the eve of trial. It suggests a manner of an approach to negotiation that's less dependent on a deadline, and that makes it most appropriate for building upon the sort of analysis that Peter's suggesting, and to undertake early negotiation. Now, what is that model? It's a model developed by Fisher and Urey in a plain language book recently published entitled Getting to Yes. And in one of the handouts, I've excerpted a summary of what they mean by bargaining on the merits or principled negotiation. And I'd like to briefly review that approach, because it's quite different an approach than you may well be familiar with. This method, called principled negotiation or negotiation on the merits, can be boiled down to 4 basic points. The 4 points define a straightforward method of negotiation that can be used under almost any circumstance. Each point deals with a basic element of negotiation and suggests what you should do about it. People. It suggests that you separate the people from the problem. Interests. The suggestion is that the negotiator ought to focus on both parties' interests rather than articulating positions. Options. Generate a variety of possibilities before deciding what to do. And criteria.
What does that mean, Don?
Well,
that's where we were talking about enlarging that zone of agreement.
And in our discussions, we both agreed that in many business disputes, there is a possibility for both sides to do better by negotiation if they explore each other's interests and try to accommodate them. And you brought up the simple interest of 2 sisters fighting over an orange, and they argued back and forth and decided best way to deal with it was to cut it in 2. And one immediately ate the pulp because she wanted the orange to eat, threw away the peel. The other immediately threw away the pulp and kept the peel because she was interested in making some marmalade. And in our experience, early enough in the dispute, there are some opportunities sometime to get away from the dollars and develop a solution that might accommodate both parties' interests as opposed to a straight haggle and saw-off on the money. And often in the traditional mode, when you're 2 years away from the initiation of the dispute and just between discoveries and facing trial, there's no room left. Either the relationship at the beginning has deteriorated, or you're so far away from a solution that it can't be seen in that light. Finally, criteria. And Urey and Fisher, really at the core of their theory, say that the negotiator ought to insist or attempt to see that the result be based on some objective standard. Now, really the method that they're talking about is significant. Start earlier rather than later. Approach the other side with some civility. Avoid posturing. If you will, recognize and make your emotions explicit, but separate them from the problem. Identify your interests. Indeed, in our model, we think that it will be important to use the zone of agreement analysis to persuade the other side as to the mutual benefit in pursuing seriously a negotiated result early in the dispute. As I mentioned, you look to find the other side's interests, not simply his position. And again, as we discussed, explore in the course of the negotiation whether there's a mutually advantageous solution or one that cuts both sides' losses and in effect creates some value. Now, obviously a question arises, will it work? And apart from our experience, and some of it is limited, there appear from other sources to be evidence that this approach will indeed succeed or can be successful. And specifically, I refer to a case in the United States that was written up in one of the law journals, where two companies, Telecredit and TRW, using a variant on principled negotiations, decided to stage argument and evidence in front of two chief executive officers as a prelude to a negotiated result. The article was written by one of the lawyers. It was successful. Once they went through their day of argument and disclosure of their case, the two executive officers were easily able to see an answer and negotiate a result that they estimate saved in total in excess of $1 million in legal fees. Write-ups of the Westinghouse uranium settlements in the United States flowing from the uranium problem suggest a similar result. And there I think you get not only examples of an application of the Fisher and Urey model, but in addition a solution that created some extra pie, with the agreement and settlements providing mixtures of cash, equipment, and buying and selling contracts in uranium rather than just a damage award that might have resulted from the conclusion of a trial.
Don, do you think that this is really practical for lawyers, or are we just dreaming?
Well, when we go back and think of the use of your analytical tools, in the course of trying to put together this paper, I had occasion personally to experience a variant of some of the decision theory, and in particular to do a probability analysis of what was a complicated lost profits calculation. And in it, we were trying to prognosticate what a trial judge would do in assessing lost profits. And we had several variables, and with the input, the variables being level of sales and margins and expenses, and with the input of a chartered accountant looking at the historical facts, we were able to make what we thought were some reasonable probability assessments as to what the likely outcome of that damage award was. And it was at least successful to the extent that those on the other side, when we put it forward as a matter of explanation in our discussions, tended to agree, and we settled the case. Now, I don't think it's appropriate in every case, and obviously simple ones like our example, it just wouldn't be worth the time and trouble.
Okay, so you think it's practical. What chance do you think there is in our existing system that lawyers are likely to adopt the use of this kind of technique? Doesn't it reduce the legal fees?
Well, yeah, I guess so, but if you keep the client, you may keep that stream of fees lasting or running over time. I think it'll have a number of uses, but it occurred to me as we were, and as we have discussed, that it will be of particular importance to corporation lawyers and in-house lawyers who are charged with the responsibility as part of their role in a company with the management of the company's legal disputes, and that they might find it as useful tools in two ways. Firstly, in analyzing and controlling, in fact, managing the dispute and using their outside experts, but as well in communicating with management. And that really leads to the question I have for you, Peter, and that is, what do you think management, the non-legal people, our clients, how do you think they'd respond finding their lawyers attempting to communicate to them through the vehicle of management concepts and analysis?
My guess is that most chief executives would likely be pretty pleased with this sort of approach. I think it allows them to feel that they have some control over what's happening. I think, as you mentioned earlier, the dispute so often seems to get shuffled off to the lawyers, and they don't hear anything back until ages later, when it becomes a question of a trial for amounts that they're afraid to even think of at the beginning. So I think that the top management of an organization are likely to feel much more comfortable that they know where they're going and that they have some chance to control events. The other thing I think that is likely to be a help is that there is, I think, and I don't mean this to be critical, but I think that there is a communications gap between any profession and management, chartered accountants and management, lawyers and management. I think dealing with the problem in these terms is likely to help management understand what the legal problem is. They'll be in terms of dealing with uncertainty and risk and choices and some attempts to cast some numbers on probable results, to think a problem through. Those are things that I think good management will tie into very, very enthusiastically. That's my guess. It might put some real pressure on in-house lawyers from management if they recognize that they could actually pull the levers this way.
Might even save a few costs.
It might indeed.
Well, that really runs us out of time and runs us out of our dog and pony show. We'll hopefully get it into a written form before too much longer.